permission because now they're paying rent. So if you want to now get them evicted again, you have to start the process all over and terminate the tenancy. So if they pay, again, make sure that it's only for use and occupancy. Most likely, they're not going to pay. So the 14 days has elapsed. You've now terminated the tenancy. You can move forward with the second step. Before we get to the second step, I just want to discuss a few other ways how you can terminate a tenancy. So this is all in the first step of terminating a tenancy. Again, the 14-day notice to quit, you can serve them. Once that elapses, the tenancy terminates. Also, if your tenant violates a provision of the lease, let's say that lease, which is very common, says you can only use the apartment for residential purposes. You find out your tenant's running a daycare, which is commercial purposes, and you want to evict them. They're in violation of the lease, which means that then you can terminate their tenancy for violating a lease provision. Now you are going to serve them with notification. Most likely your lease, again, consult your lease, consult your attorney about your lease, will have a provision in there stating if they violate the lease, you only need to give them 7 days notice. 7 days is pretty much the standard. So if that's in the lease and they violate a term of the lease, not non-payment of rent. Be very clear that non-payment of rent is always a 14-day notice to quit. But if they're violating another provision in the lease, it may call for in the lease that you only need to give them 7 days notice. Once you give them that notice, then their tenancy terminates, then you can move forward with the summary process eviction. Also, the tenancy might terminate if the tenant is using the apartment for illegal purposes. So prostitution, gambling, if they're doing something illegal, under Massachusetts law that falls under the law, it may then terminate the tenancy. So then you can move forward with the eviction process. So once you're clear and absolutely positive that the tenancy has been terminated, now you can move forward with the eviction process. So what you're going to do is decide, the first step is to decide where you're going to file. You can file in district court, and if you have a housing court that's in the jurisdiction, you can file in housing court. You really need to be certain as a landlord to weigh your options on district versus housing. District court is not as familiar with the landlord-tenant laws. They're not as pro-tenant. They tend to be a little more pro-landlord. So if you can file in district court, that may be the way you want to go as a landlord. However, a tenant has a right to get the case transferred to housing court. Housing court is much more pro-tenant. They're very familiar with the laws. That's all they do. Every Thursday is their eviction day. They have hundreds of people in there every week. The judges are familiar with the process. It's efficient, which sometimes is good for a landlord. But if you file in district court and the tenant wants to have it transferred to housing court, it's automatically going to delay the process. So as a landlord, you might want to just say, you know what, I have a feeling that this tenant knows their stuff. They're going to end up getting it transferred anyway. I just want them out of here. I have great reasons. You know, they've tampered with the fire alarms. They haven't paid rent in 6 months. You might want to just skip and go to housing court. Again, you just have to weigh it before you start the process on which is going to be better for your certain circumstances. So once you decide where to file, let's say you file in Boston Housing Court, you are going to request a complaint and summons, and you can either fill it out, you can have an attorney fill it out, and sometimes a constable is familiar with it. Again, if you hire anyone, especially a constable, make sure that they're familiar with the laws and that they understand the different dates, because your complaint has very specific dates on it. There's what's called an entry date, and that entry date is when you must file summons and complaint, and the summons with a proof of service that has been served on your tenant. That's the date that must be filed. So if you request a complaint and summons from the housing court, you fill it out, you have your tenant served with it. The entry date is going to be at least 7 days after that date, no more than 30, and it's a Monday. So there's some calculations that you have to do. And that entry date then says, on this Monday, I'm going to file the complaint and the summons with proof of service in the housing court. Once that entry date passes, the tenant then has an opportunity to answer you and say they admit or deny to whatever you're alleging in the complaint. And that's always within 7 days after the entry date. Then there's also the which is always scheduled for the second Thursday after the entry date. So the entry date's a Monday, a few days pass, it's one Thursday, and then the next week is the trial date. Again, if you have a tenant who is familiar with laws, they have a lot more rights than you do. If they request discovery, which is they serve you with a document called interrogatories, and they want you to answer a bunch of questions, where they want you to provide them with some documents, they can request that out of you. It automatically delays the process now 10 days, or 2 weeks really. They have 10 days, you have 10 days to answer them, but it pretty much always is going to postpone that trial date another 2 weeks. So be careful that, you might think that your trial date is going to be about a week and a half. It might then be about a month out. Once you go to court, you have your trial date. It's court. You need to prepare for it. You have to have witnesses if you need them. You need exhibits. You have to have examination questions ready. You are going to put on your case in front of the judge on why this person should be evicted. And the tenant is going to do the same thing. They're going to put on their case of why you shouldn't be evicted. So as I said, in Boston Housing Court, every Thursday is a summary process cases. Everyone goes in. It's like a huge cattle call. There's hundreds of people there. They ask the tenant and they ask the landlord if you'd like to go to mediation. It's a voluntary process. Both parties have to agree. So if the tenant wants to go to mediation and you don't want to, you don't want to waste time, you just want to go in front of the judge, you can say no. You only are forced to go to mediation if you both agree to it. So if you do decide to go to mediation, you go downstairs and you meet with a mediator who's appointed by the court. You both discuss the issues that are going on. Maybe this person hasn't paid rent in 6 months. This person says there's a bunch of violations in the apartment. You can maybe try to come to some sort of agreement. The agreement's written up, and then you go in front of the judge, and the judge generally, as long as it's reasonable, approves it. If you decide you want to skip that stage, you can just go straight in front of the judge. You put on your case. This is another step where you might think you're going to get in there and get some resolution, and the tenant says, I want a jury trial. I want this to go in front of my peers, and they're going to decide whether I get evicted. Well, I will tell you the last time we requested a jury trial in Boston Housing Court, it was about a 3-month waiting period. So now you're getting another 3 months of most likely not payment of rent, and someone living in your home and cannot, again, do anything about it until that judge issues an execution and tells them that they have to leave. So if the tenant requests a jury trial, it's automatically going to be awarded. This does not always happen, so the tenant might not know they're allowed to do this, or they might choose that they want to get this resolved that day. Put on your case if you have your trial the day that it's scheduled. The judge most likely will take it under advisement. He may issue a decision at that time. He may issue judgment for one party. If not, the judge will take it under advisement and you'll get something in the mail, either saying that the judge found for the tenant or found for the landlord. If they found for the tenant, you're out of luck. Tenant's in there, let's hope they keep paying rent. If you have other ways of getting evicted, if there's something in the process that got messed up, start all over again. If the judgment's for the landlord, 10 days after the judgment date, you'll get an execution. And what that execution does is that piece of paper is what finally allows you to get your tenant out of the apartment. Again, this happens 10 days after the judgment date, and it's only valid for 3 months. So be careful that you use it within the 3 months or it's gone. So use it or lose it. If your tenant comes to you and says, oh, I promise I'm going to leave, just give me another week, just give me another week, and before you know it, 3 months have passed, you have to start the process all over again. And I'm not talking about filing in court. I'm talking about terminating their tenancy and doing the whole thing over again. So be certain, if you want to get them evicted, you use that execution within 3 months. So once you've decided you're going to use it, then you hopefully have your tenant move out. A lot of times if they're told by a judge they need to leave, they'll leave. If they don't want to leave, that's when you need to hire a constable. Make sure that constable is extremely aware of the whole process and knows the laws surrounding it. You, even at this stage, are still responsible for your tenant's belongings. So they're in the apartment, an execution has been issued, and constable comes, packs up all their stuff. You need to store it, make sure it's stored appropriately, Make sure that you've paid a deposit so that the storage company allows the furniture to come in. You may be able to get reimbursed from the tenant. Most likely you're not going to. So at this stage, a lot of times, again, a lot of this process is circumstantial, specific to your case, and you have to weigh your options. So if you go in there and you have an execution and your tenant refuses to move but says, I really just give me 2 weeks and I will move, I promise, you may want to trust them and see if they'll move within 2 weeks. Again, make sure that this does not get near that 3-month period so that you can still use the execution. But it's going to cost you thousands of dollars to get your tenant out. And it's going to cost you money to get the constable to come in and pack up all your belongings. So you want to make sure that if there's any way that you can come to some sort of agreement with your tenant before you go and hire a constable, before you go and hire a storage company, if possible to come to an agreement with them, you can do that. It might not be possible, they might just not want to leave and might refuse to leave. But it's always good to try to negotiate with your tenant. They may just need some time, they may be willing to cooperate if they're given just a little extra time. But again, until that execution is given to you, you cannot move their things, you cannot do anything with them. That's the final process. Any time from when you try to terminate their tenancy all the way until the day you have the constable try to pack those belongings up, there's always room for negotiation and trying to come to an agreement with your tenant. So if that's possible, you can try to do that. I don't want to scare you thinking that every tenant, it's going to be 6 months before you get them out. But this is the process if it goes that long. There's always stages where they might move out after you serve them the notice to quit. They might move out after they get a summons. They might move out after they go to court. There's always times where the process can be shortened, but this is if it goes the entire length. So that's that process. So I think I've kind of discussed all the main topics we were going to get to. I just want to again reiterate, always make sure you give receipts. And if you're a tenant, always make sure you get a receipt. Always have communication in writing. If there's something wrong with your apartment, put it in writing to your landlord. If there's an issue with your tenant, the landlord should put it in writing to the tenant. You want to make sure that if you have to go to court, that you have documentation showing that you were aware as the tenant that there was problems in your apartment, or as the landlord, you want to make sure that you've shown that you've tried to get conditions in the apartment fixed and that your tenant refuses to cooperate. You really just want to make sure everything's in writing, including correspondences and including the receipts. And always, always, always consult with local city ordinances, state sanitary codes. Make sure that that apartment is in compliance and that anything you're doing is in compliance with the law. You can always consult an attorney who can tell you information. I'm hoping the information I gave you today will assist you. And I think if you keep those things in mind going